In the name of Allah, the most gracious, the most merciful, welcome and greetings. We meet you this afternoon as part of the virtual sessions held by the Communication and Financial Knowledge Center. We are going to discuss today with our guest the role of institutional arbitration in the new government tenders and procurement law. While the efforts Saudi Arabia is exerting to support the institutional arbitration environment and to support Vision 2030 that aims at supporting alternatives for institutional arbitration settlements to facilitate doing business and to attract the local and foreign investment through providing effective alternatives to settle the commercial disputes according to the best international standards. And we are going to discuss few topics today. We are going to discuss the added value of financial arbitration and the conditions of arbitration within the tenders and procurement law. And on your behalf, I'm welcoming the guests we have today. Dr. Hamid Mira, the head of the Saudi Center for Commercial Arbitration, and Mr. Hamid Majid Turkey, the head of legal affairs at CSA. And unfortunately, we cannot host Dr. Mustafa Abdul Ghaffar. So, welcome everybody, and allow me before starting our discussion to view an overview of the Saudi Center of Commercial Arbitration presented by Mr. Musad Al-Kharf, the head of business development and partnership development in the center. If you may, Mr. Musad, welcome, and we are pleased to view with you the Saudi Center for Commercial Arbitration since its establishment according to the Council of Ministers in 1435, and it was also approved by the Saudi Council of Ministers at 2019 to make the center as an independent center financially and managerially speaking. And also, it's the head of the center is designated by itself, and in order to support the international standards, so we hold international standards with the US Association of Arbitration in order to transfer knowledge according to international standards. Also, the legislation allowed for the enablement to practice the institutional arbitration through providing some royal decrees and laws and regulations in order to support the practices. Also, for the public enablement, many government entities like the Ministry of Commerce supported the practices of institutional arbitration through different projects with the Saudi Center for Commercial Arbitration. And also in relevance to this, the Minister of Finance approved 14 model contracts according to the new law of tenders and procurement law, where they included the institutional arbitration as a modular condition in the contracts. Also for the judiciary enablement, all the judicial entities supported the center through many quantitative projects to support the practices. For the readiness of the center in terms of the organization, we are organizing all the disputes according to international standards, and in terms of the infrastructure, the center has many branches in Saudi Arabia to support all the technical and technological arbitration sessions, and also in order to cope with the international standards. The center we has the consultative committee to revise and proofread all the rules, and this consists of 14 international experts. After conducting a survey in Saudi Arabia, the center started to provide many products and services to cope with all business sectors, like the expedited procedures, the protocols, the nomination and designation services, and dispute settlement. Also, in order to deal with the COVID-19 pandemic as required or as necessary, the center uh, dealt well with the COVID-19 pandemic through launching a program to expedite the disputes within this pandemic. Also, the center established a committee for the technical administrative requests. And the center has many arbitrators in all experts from all nationalities and in all languages. And the outcome of this is to include many international and national companies according to the standards, and this added to the center a big number of disputes and issues from all nationalities. And thank you. Thank you, Mr. Msad, for this overview, and welcome again. And our topics today, the first topic we have, as we saw the overview of the Saudi Center for Commercial Arbitration, and we refer to the government enablement for dispute settlement, especially arbitration. Why arbitration, not adjudication, especially in public contracts? First of all, I would like to thank you, Mr. Abdulaziz, and I would like to thank the Ministry of Finance through the Communication and Financial Knowledge Center for holding this session. The human relations in general include the different points of view, and disputes are available at any time. So how do we include this in our contracts to avoid the commercial disputes or mitigate the disputes, and how to settle the disputes, if any? We have the golden answer: arbitration, mediation, or the alternatives of dispute settlement. Before summarizing my answer, why arbitration, why dispute settlement, I would like to refer to something. When we talk about commercial contracts, so arbitration does not limit the role of national jurisdiction. However, the alternatives are complementary and achieve the message of the jurisdiction in order to achieve justice. However, many times they are complementary to each other, like dark and light, weakness and perfection. However, in this context, they are complementary to each other, adjudication and arbitration. So why arbitration, especially as an alternative to settle the commercial disputes, whether they are partners or they include international companies? Why arbitration? First, the most important thing for any businessmen or business sectors or companies, they are trying to protect their reputation. That's why they seek confidentiality and dispute settlement. So what makes companies and businesses with all sectors, they seek arbitration because it's confidential. Before that, arbitration or arbitration centers cannot say or disclose who are the parties of the dispute. Also, the deliberations or the arbitration verdict, and this is essential, and this leads us back to what we started with, because this enables and complements the jurisdiction and the judiciary sector because it's the final resort. However, in arbitration and mediation and other alternatives, they seek the way they want to settle the dispute. That's why confidentiality is one of the advantages of arbitration. Second, the options of parties. I have many examples. The Saudi arbitration law is one of the laws that added more a value to arbitration. The second reason is having many options for parties. For example, the governing law. In arbitration, you can select any governing law, whether a Saudi law or any other law, and this is an advantage, and it's even more important for foreign investors while they are not well aware of the national law or the country they are investing in. Also, it's flexible because we can select the place of arbitration, especially in commercial arbitration or in institutional arbitration. It could be held anywhere and they could be in different countries, and this facilitates a lot of logistics and also decreases the cost. Also, adjudication that doesn't provide the selection of the time of settlement and other options. Also, it's flexible because of the language in adjudication in any country. It's very important in procedures. It has to be in the language of the country. However, in arbitration could be conducted in any language. Also, the choice or selection of the arbitrator, it's very flexible in Saudi Arabia to select the arbitrator regardless of the nationality, race, and this provides more flexibility in terms of the specialization or specialty, and this achieves flexibility and efficiency. So this is essential for all of us, and this makes the business sectors resort to arbitration, and this reflects more justice. And I don't want to refer to speed because it's not always positive, because we have to follow the procedures in order to achieve justice or effective justice. It's the speed without compromising the procedures of justice. So if they are choosing the arbitrator, the expert, if they can select the laws and the place, so this all reflects the flexibility and speed in the accomplishment of settlement and to achieve effective justice. Fourth, it's very important for foreign investors and for the public sector and businesses is the implementation or execution of verdicts. And it's compatible with the ministerial, the international law, and also the arbitration verdicts are final and cannot be appealed. In many countries, you can appeal 3 or 4 times. However, this gives us more flexibility and more accomplishment. Something also important in the execution part is the execution of the foreign verdicts or sentences. We know that the execution of verdicts is subject to a lot of things like the judicial cooperation agreements or many other aspects. However, in arbitration, the whole we have New York Convention for the recognition of arbitration verdicts. Saudi Arabia is one of the signatories of this convention, and this gives us more flexibility for any arbitration verdict that is issued in any country. It could be applicable to many other countries. In conclusion, Why the government entities resort to this? Because this matters to the public sector, and also this improves the efficiency and especially the financial and technical efficiency. For instance, the infrastructure projects, and this also saves a lot of costs due to the delay in arbitration, and this provides more options, especially in the international contracting, because this opens the door for more contracts instead of adjudication and a higher rate of production. This is all important to the public tenders and procurement law. Thank you so much. And I would like to emphasize on the flexibility and facilitation and the freedom of selection and the specialty. Thank you so much, Dr. Hamid. Now I move to Mr. Majid. In terms of the public expenditure, so the new government tenders and procurement law stated the rules of dispute settlement. So is this an alternative to what we had before? The CSE is always seeking the application of the model contracts and the alternatives. And one of these alternatives is the Council of Technical Dispute Settlement, and uh, arbitration is not applicable to this, or the private adjudication, or the article of dispute settlement, the technical dispute settlement. This is subject to some conditions, terms and conditions. And as the council stated, according to the Article 155, and for the private adjudication is subject to model contracts and the technical dispute settlement, that there must be a team of a representative of the public institution and the contractor, and the Ministry of Finance appoints another member, and this could be slightly different from arbitration, the modular arbitration contracts, or according to the Saudi law. In this case, one of the parties of the conflict is not appointed by either parties, and according to the regulation, if somebody doesn't have justice, they can resort to another judicial institution, and the Council of Dispute Settlement is not an alternative of arbitration. However, it's another way in case of there is some delay in projects. Thank you, Mr. Majid. So technical dispute settlement is one of the ways of dispute settlement according to the law to enable the alternatives. Another question, Mr. Majid, the new law of tenders and procurement, does it include this in the contracts with the vendors or suppliers in order to provide services or by purchasing products? Yes, indeed. The new government tenders and procurement law in the second article and Article 92, after the approval of the minister, so the parties can resort to arbitration, and according to the executive regulation is providing more details on this, and the Article 18 of the model contracts approved by the minister stated many details and headlines and the key requirements in order to conclude the agreement, and for the government entities must apply this condition in order to conclude an agreement with the parties. Dr. Hamid, As we know that the open arbitration has been practiced in Saudi Arabia many years ago. However, many arbitration cases were conducted in international centers out of Saudi Arabia. So is this an indication that the institutional arbitration is much better than the traditional arbitration? And is this why you added this model contracts to the system or law? This is an important question, and it's no secret when we used to revise many institutional arbitration reports, the cases where two Saudi parties, these cases and the region could be 20% of the region. Both parties are Saudis, and this is a national loss for us. And this was the reason to have an institutional arbitration. The free arbitration or open arbitration is available in many sectors. However, according to Vision 2030, we have a lot of mega projects and foreign investments. That's why we need this in institutional arbitration. While we are having this transformation, we need more institutionalization, professionalism, and openness to the world. Before answering, let's say what is institutional arbitration. Some people might think it's just a council or an office. However, it's not just this. Institutional arbitration is moderated by a specialized center according to professional standards, and it's conducted by a professional team, the board of arbitrators, in order to reach out to justice. And this is very important. And before emphasizing on the importance of an institutional arbitration, I would like to clarify something. In institutional arbitration encourages the parties to select the arbitrator that they agree on, even if it's not part of the council, and you can select its time and place of the arbitration or mediation, and the parties could be conducted anywhere in the world, whether on location or virtually. So this is all part of the institutional arbitration. Why did we see many cases are being conducted outside or abroad? There are a lot of values protected by the institutional arbitration within this momentum of procedures. For instance, we don't want to uni agreement or unilateral agreement for one of the parties with the arbitrator. So we want to protect the relationship with of the parties with the arbitrator in order to avoid many wrong practices, because the arbitrator is not a representative of the parties. So that's why the institutional arbitration center is supervising the case. It's also more flexible and professional and effective. In any free arbitration, they have to resort to the jurisdiction, and this takes time. However, in an institutional arbitration, for instance, the Saudi Center for Commercial Arbitration, we have a mechanism if there is no agreement to select the arbitrator. So the Saudi Center of Commercial Arbitration is doing the role of the court to appoint or designate the arbitrators, and this saves a lot of time and effort and provides more professionalism. And also how do we select the arbitrators? It's way too far than nepotism or any prejudice. So we have the mechanism of selection. That's why we arrange and collecting points. That's how we select the arbitrators, and also the center has mechanisms in order to join as an arbitrator to the center. So by the end, the Saudi center, for instance, has more than 51 specialties like gas and oil, contracting, real estate, and very specific specialties, 25 nationalities, 18 languages, and this provides the parties the access and the ability to have this amount of options. And also for the detailed procedures, we have these procedures consist of 42 pages. If there is a contract with the public sector in case of dispute, so it's resorted to the Saudi center, we added 40 pages to the contract that protects the parties from any other bad options. So don't have only procedures. However, we have hundreds of pages of detailed procedures. We have more than 130 models to support the parties to be more professional, to have more professionalism. And anywhere in the world, including Saudi Arabia, we have some, as for the center, as an institutional arbitration center, we revised the draft of the contracts in order to revise the formalities of the contracts. There are many examples, especially in public contracts or or professional contracts, when there is a foreign investor. Institutional arbitration is a need. It's not a complementary procedure, and institutional arbitration enhances and supports the will of the parties and improves the adjudication. Thank you, Dr. Hamid. We are going to play a short video presenting the efforts of Saudi Arabia in commercial arbitration. Open your horizon and take your road and select the peace of mind and launch your business. The new Saudi Arabia, exceptional opportunities, mega projects in an investment environment that is competitive, regulated, and subject to international agreements, and coping with the international standards for the mediation and commercial arbitration. Today, the commercial arbitration industry in Saudi Arabia is a reality that is based on professional rules according to the best international practices, and in order to have independency and provide the judicial support. And furthermore, the Saudi Arbitration Center is adopting many applications in the arbitration industry in order to meet the demands of investors. We have the platform for electronic arbitration and the emergency arbitrator. There has been many years, but now we saved a lot of time. So the environment now is more attractive for arbitration and businesses. Welcome back again in our webinar today, where we are discussing the role of commercial institutional arbitration in the new procurement and tenders law. while we are having big contracts for the government sector and while they are subject to disputes, what's the impact of these alternatives and how this attributes to the success of these projects? This is an extension to what I said before. The institutional arbitration supervised by the center. We have many specialties. We have a professional list of arbitrators. They are specialized in more than 51 specialties, and this adds more professionalism, speed, and save more costs. Also, the technical team here in the center, we have an administrative technical team. We have a small team, however, they speak 7 languages. Also specialty in terms of sectors. It's also we have also specialties in terms of legalities and the judicial aspect. We have different public common law and civil law and the Islamic Sharia. We have many law specialties here. Also, in terms of having many languages and realizing the reality and the practices in Saudi Arabia and the whole region and internationally is also important. Also, international strategic partnerships. Since its inception, we concluded a strategic partnership with one of the most important institutions in the world, and we concluded many other strategic partnerships in order to be able to have many expertise to serve the customers or the parties of the arbitration. And this is even more important in terms of the government or public laws or contracts. And also for another aspect, and this is due to the good leadership of Saudi Arabia, that because we are adopting the international standards and the center is independent from the public and private sectors. Yes, this is one of the most important alternatives to settle disputes. So for the government entity, before resorting to arbitration, do they need to ask for exception to resort to arbitration? And what are the changes or amendments to the government tenders and procurement law? As I understand, the government entities cannot resort to arbitration until it's approved by the Council of Ministers. However, in this Article 10, there was an exception that prevents the public entities. However, it's allowed or permitted if there is another article, and this exceptional article was added to the government and tenders law and provided more regulation. And this law or regulation was issued in Article 54. What if the government institution wants to make sure it's compatible with the situation? How can we conclude such agreement and how this could be concluded between the government entity and the executive party? We have to comply with the Article 50, 154 and 98 of the Government Tenders and Procurement Law. And Article 92 stated that there must be an approval by the Minister of Finance to resort to arbitration. However, there could be an understanding. However, if there is any contract including the condition of arbitration, it has to be approved by the Minister of Finance. On the other hand, for the tenders or the competitors, if there is a foreign company providing a service or product, how could they resort to settle their disputes through arbitration, or how they express such desire, or how is the mechanism to accept such arbitration resortion? If the company is foreign, it's also applicable to them, whether the model is complex or simple. For the condition of arbitration, this is subject to the government tenders and procurement law and its two regulations. So before starting the procedures of competition or tendering, this has to be submitted with the tendering request before its proposition. And this is to guarantee equal opportunities for the tenderers, and according to the principles of the law, the documents must have the terms and conditions of the party. So resorting to arbitration for dispute settlement is included by the government entity, and it could be also an exception if the tenderer is tendering on two phases. If there's no enough conditions, so the government entity could explore or find out which is best, the adjudication or arbitration in some cases, in some disputes. Also, for the two phases tendering, we have the RFI, request for information. This is the first phase, and based on the replies of the tenderers, and they can express their interest if they want to include arbitration as a condition or article while taking the necessary considerations, and then they must take the approval of the Ministry of Finance. Thank you so much, Mr. Majid. Going back to Dr. Hamid, we would like to know what are the solutions provided by the Saudi Center for Commercial Arbitration, as you are responsible for institutional arbitration, in order to apply neutrality, the principle of neutrality. We have a wide spectrum and different needs for sectors and businesses according to their sizes and other aspects. So we have a lot of services and products. First, we have the institutional arbitration or traditional arbitration. This includes almost all sectors. We saw many sectors during the past 4 years. There is no limit for the types or number of arbitration cases in our center. Also, we have the expedited procedure, and this is a service provided to small and medium-sized enterprises for the disputes of 4 million riyals or less. because it's faster and easier, and also for the duration is less, and this saves about 30% of the cost of the traditional arbitration. And we have also the emergency arbitration, and this is for special cases in order to protect the assets of the case. So within 24 hours, the center can appoint an arbitrator, and there is a verdict, an emergent verdict that is issued within 30 days. And fourth, we have online dispute resolution through the platform and the protocol. And this was even before the pandemic, and it's a product targeting the micro companies for the disputes of 200,000 reals or less. And it's faster and less costly, and it's coping with this kind of businesses. Six, we have many services to support the free arbitration, like the nomination and designation of arbitrators. So they can nominate or resort to the nomination or designation, and this is also available for the judicial sectors. Six, the technical administrative dispute settlement cases. Maybe the number of arbitrators, the place, the neutrality of the arbitrators. So sometimes this could be resorted to the jurisdiction. However, the center provided that they can resort to the center, and we settle these issues of the disputes like mediation or emergent mediation and the facilitation of mediation according to the new commercial courts law in Saudi Arabia. And this has been practiced long time ago and has been provided to many parties from over 10 countries. Many services, yes. We have a short break and then we will continue our discussion. Thank you. Welcome to the new tenders and procurement law. It was validated in order to provide the many services to the government entities to help planning for the procurement and businesses. What are the different ways? We have 5 new contracting ways. You select the one that's suitable for you first. The framework agreements. This is for the unified procurement for some procurements. Second, the tendering on 2 phases. First, the description of the project, and then the tenderers provide their own information. And then the second phase is for the detailed description. And third, we open the room for tendering. However, each tenderer must must be providing a list offer. And also for the knowledge transfer, we have contracts for the localization of new industries and to provide more opportunities. However, if we have technical or artistic contracting, it could be subject to the samples, and you can visit our website on the for the Ministry of Finance, where you can find this as an enablement to improve the efficiency of government expenditure and to support the economy and to support the SMEs and to achieve the targets of Vision 2030 of Saudi Arabia. Welcome back again for our last session of this webinar. And in terms of government spending, so the model article stated by the center, is it necessary? Is it an exception? How do you see this article for the government spending? The arbitration article in the contracts could be changed according to the instructions and the models. The government entity, if it wants to conclude a contract with another party, they have to include this, and there are also instructions in the model of arbitration, and it stated that the examples referred to below is for guidance, and also the Saudi Center for Commercial Arbitration was referred to in the contracts in the fields of that are subject to changes, and it could be revised, removed, or deleted. And also the selection of the arbitration entities is subject to the type of the contract. Maybe one of the licensed centers in Saudi Arabia, like the Saudi Center for Real Estate Arbitration and the Engineering Arbitration Center. Another question for including the condition of arbitration in the model contracts. Does this include the contracts of less than 100 million riyals? To answer this, I would like to refer back to the regulation, the executive regulation. The first article of section 145, and that states this amount for the contracts that are less than 100 million riyals. So this is a law. The Minister of Finance can change this article upon his discretion. Dr. Hamid, to conclude this last topic, do you, do you have any final remarks in 2 minutes in order to move to the questions of the audience? I think we are witnessing a great time of the nation. Many efforts by the public sector, private sector, or the third sector, and also international organizations are all contributing to achieving Vision 2030, and also the center is exerting a lot of effort to be part of this national accomplishment, and many people are asking why the center is important. I would like to sum this up. It's the only center that was established by the Council of Ministers resolution, and it's the only center where the board of members is appointed by a Council of Ministers resolution, and it's also concerned with the public and private sectors at the same time, especially with the public contracts. Many times the foreign investors don't like to resort to a government center, and there was a condition that the head of the center or the members cannot be working for the government, and they cannot be affiliated financially or managerially to a government entity. And also we have many partnerships. Also, this center is working at the highest level with an international team in order to meet the demands of the whole nation and to support the foreign investors and to facilitate doing business and attracting national and foreign investments. So this center is working for the nation. However, we are addressing the whole world at the same time. Thank you so much, Dr. Hamid, Dr. Majid. Do you have any final remarks in 2 minutes? All thanks to you and the Communication and Financial Knowledge Center and the Saudi Center for Commercial Arbitration, and Dr. Hamid, the moderator or presenter for this amazing organization, and for shedding the light on these topics, because this all contributes to the achievement of Vision 2030 of Saudi Arabia. Thank you so much. A short break, and then we will come back to your questions. Let's welcome back again. We have many questions and inquiries. Maybe we have already answered this. Let's start with Mr. Majid. There is a question that we refer to. What are the objectives and aspirations of the government spending center in order to support the government spending? We have many rules and mandates in terms of regulation, or according to the government tenders and procurement law, we have to transfer knowledge and provide in training courses, and the government tenders and procurement law has many reforms to achieve the efficiency of spending, and that includes many initiatives in partnership with the Ministry of Finance in order to achieve the highest level of common interest, and the center will keep contributing to this. Thank you so much. Another question to Dr. Hamid. For the arbitration of government contracts might be slightly different than other contracts. So the Saudi Center for Commercial Arbitration, are you ready for such arbitration, and what are the steps you have been taken? We referred to this earlier. The center has a professional team that is specialized and can manage different sizes and types of issues or cases. This is our most important preparation, and realize that our role is very important to meet the national demands and the demands of investors. Also, we are adopting the best international practices. We had many acknowledgements from and recognition from many international centers, and we were nominated by many centers. And we have a program that is one of the best in programs to deal with this pandemic, and also the rules, the environment, and qualification of national and international arbitrators and experts. And now we have an awareness part as well in order through communication with the if spend and efficiency center and the other centers. This all improves the government procurement and contracts. One last question with Mr. Majid. Is there a department or a board to include the condition of arbitration in contracts, and how easy is this? To include the condition of arbitration is subject to the Minister of Finance, and according to Article 154, this requires a prior approval by the Ministry of Finance, and I cannot answer this fully now. However, if maybe we can spread such information or through the Communication and Financial Knowledge Center, you can provide us with more information. In conclusion of this webinar, I would like to thank all the organizers from the Communication and Financial Knowledge Center and the Saudi Center for Commercial Arbitration. And also thanks to our guest speakers and thanks to all the audience for your interaction, and peace be upon you. Thank you.